Welcome back, everyone. I'd like to introduce Ryan Smith, one of our assistant managers, prep instructor, condo expert, we'll say.
Sure, let's go with that.
We'll go with that.
Has not done his area course yet, just so, if anyone out there was feeling bad when Dave was giving you crap before, I have mine scheduled to do tomorrow. So it's going to be done out of the way well before the end of the month, but I'm just digressing. I haven't done it yet. So.
We did threaten to whip and beat them if
they did. But. Indeed.
So we've had changes come in effective January 1st to the Condo Act. A big one, really. It took a long time for this to actually get done. So what were we looking at? Why did we get there?
Well, okay, so I'm not going to bore you to death with everything, but just sort of a quick overview. These changes were contemplated originally back in 2014. So that was the previous Conservative government, okay? Mm-hmm. Over the past 6 years, these changes have been sort of phased out and brought in different chunks over the course of time. And there's two pieces of legislation that get affected by this. There's the Condominium Act, and then there's the regulation. So the last change that we were waiting for was the final change to the regulation. And that was originally supposed to come into effect on July the 1st of this year. Those were changes that were contemplated by the NDP government. So when the Conservatives won again in the spring, they wanted to vet those changes before they were prepared to push them out. So just prior to the changes rolling out in July, the Minister of Red Tape stepped in and said, we want to take a look at this. We want to make sure that all this jives with our mandate before we roll it out. We're going to push this off until January the 1st. So now finally we've reached that anniversary date, and this completes in its entirety the changes that started 6 years ago to the Act and the regulation. The only thing that's coming down the pipe still, but then we can talk about this in a little bit more detail, I don't have a lot of information on it, is they're looking at bringing condominium managers under the purview of RECA.
Yes.
Now, RECA obviously has their own transitional issues right now. Nobody's really sure how the council is going to exist in the future, in what capacity, whatever. So don't expect that to happen anytime soon, but that would be kind of the last phase of all of this. At the end of the day, that's not really going to affect us as an industry of real estate agents, but that's kind of the final thing that we're all waiting for. That could be 2 years from now.
Yeah, my understanding, Doug Dixon at RECA is heading up that committee and working on what they want it to look like, what the courses will be, the requirements. I think it's good that they'll be brought into the fold when we already see like appraisers and mortgage and everything folded in under. It's an incredibly important part, and there really is very little oversight.
Well, and we talk nonstop in our courses about how there are no condominium police. I mean, if you have a grievance as an owner against your board or against your management company, there's really no avenue for you to explore to deal with that. Hopefully, by putting the condominium managers under the purview of RECA, there will be a little bit more accountability in the same way that there's accountability in our industry. You know, if a consumer has a bad transaction with a real estate agent, first and foremost, you can go to the broker, but above that, you can take your grievances to RECA, and then RECA has some powers to deal with that agent. Mm-hmm. So arguably, it would work the same way for the condo management side. But again, that's not happening tomorrow. We're lucky if that's correct. Yeah.
Well, it took them almost 6 years to get some rules changes that we identified a long time ago were required.
Yes, exactly.
So maybe we should chat about that. So what are the important takeaways from the changes? For me, a lot of what I saw with setting mandatory rates, expectations, timelines were important.
Yeah, I would say, so I've been doing a little bit of research, I would say a lot of research over the past few days just to really understand, in preparation for this, to sort of, so I can break it down for everybody at CIR. And there were bulletins put out by area, and then there were bulletins put out by the Alberta government, and they don't contradict each other, but some of the bulletins leave out information. They have a different slant on things. They might leave out some of the information. So one of the things I did over the weekend is I went and I looked at the regulations, the new regulations in their entirety. And one of the great resources that Service Alberta has available on their website is you can get a copy of the new regulations, and then it's all of the changes have been highlighted in green with a small synopsis of the changes in the margin. So for those of you that have absolutely nothing better to do over the next couple days, you can get a copy of the new condo regulations and read them cover to cover. Maybe boil a bunch of coffee or drink a bunch of Red Bull before you do it, however you need to stay awake. But it is really good information. But to sort of summarize all of this, let's break it down into sort of three chunks. So there's the document piece, there's the insurance piece, And then there's the piece about reserve fund studies.
Yep.
So let's talk about the document piece first, because I think that's probably the most sort of applicable to us as agents, right? And I guess before we dive into this, none of these changes are going to fundamentally change how a real estate agent does their job.
No.
You know, I think you had a phone call, you were telling me the other day or last week from an agent out of your office who was asking about, you know, and I don't want to say panicked because that's a bit of an exaggeration, but they were concerned or they were really unsure about how these changes were going to affect them. The reality is that they probably won't. These changes were intended in most cases to improve the lives of unit owners, particularly as it pertains to the documents. So it's not really going to impact us as an industry specifically, but it's important that we're certainly aware of these things, right?
Well, and where I see it important for the realtor is when you're initially meeting either with a person buying or going to list, being able to fully explain the process of condo docs, how we'll receive them, expected costs, just so that we're doing and providing our expert analysis of how the listing is going to go, what they should expect, why they get certain documents right away, what the buyers can expect, why we want to make sure those conditions in, really understanding that they have, you know, they're buying into a corporation, all of that goes with it.
You bet.
So really it's just about being able to be fully professional in front of your clients.
Well, and on the listing side, I mean, prior to these changes taking effect, when you were sitting down with a client to explain to them that they needed a full set of condominium documents, there was a lot of uncertainty in the cost of those. I mean, some corporations would mark them up to the point of, I mean, I've never had a personal situation like this, but I know of somebody who paid $1,200 for their condo docs. Mm-hmm. You know, the average was probably 5 or 6, right? You know, maybe it was 7 or 8, depending on the corporation or whatever. Well, now there's more cost certainty because what they've brought in now are caps for these fees that can be charged by corporations or the management companies. And so what they've done is for all of the sort of standard documents or supplemental documents, we'll call them. So things like the meeting minutes from the board of directors or a copy of, you know, the insurance certificate, for example. They're all capped at $10 on a base fee, but they have the ability to charge up to $30 for a rush service. So a rush service would be within 3 days. Now, I was hopeful that they were going to remove this idea of a rush fee when the Minister of Red Tape stepped in to review these things over the past 6 months. Because what happened, and what will continue to happen, I'll almost guarantee it, is that management companies are going to default to the allotted time frame that the Act gives them. And what I mean by that is Section 44 of the Condominium Act gives them 10 days to satisfy a request for documents. Mm-hmm. So what management companies were doing were saying, okay, fine, these documents are $10 each. You can have them in 10 days. The reality of a real estate transaction is you don't have 10 days to get the document package together before you send it over to a buyer's agent. So what was happening was, almost by default, owners were having to pay the $30 rush fee per document in order to get the documents in a reasonable time to facilitate a transaction. That is going to continue. I'll almost guarantee it. So,
and there are ways, though, when I talk to people about it, if you're listing a condo, go in, create your cart, know exactly what you're going to need, download everything and get it as much as you can so that you limit the requirement to order a rush. So really you're looking at a disclosure letter. And although it's interesting to see now all the things they used to include in the disclosure letter, they're now breaking them out as individual documents so they can charge more for them.
Well, so this is another interesting change that they've made. The government now, with these changes to the regulation, they have forced management companies to include certain things in the disclosure letter.
Which was nice to see.
Correct. So the statements about, you know, any written demand in excess of $5,000 on the corporation, or any unsatisfied judgment against the corporation, or any structural deficiencies that the corporation is aware of. Those statements are required to be part of what they're calling the information statement, what we would typically call a disclosure letter. Mm-hmm. And that disclosure letter has a fee cap on it of $100 as a base fee, or $150 rush. So to your point earlier, that is a really time-sensitive thing, right? If I take a listing for a condo today, I'm not going to encourage my client to go out and purchase a disclosure letter, because if we don't get an offer for 60 days, that disclosure letter is of no use to us, because the buyer is going to look at it and go, well, this is 60 days old. How do I know nothing has changed? So again, to your point, I think it's a great tip. If you're taking a condo listing and you're trying to save your sellers money, encourage them to buy the more static documents, the ones that are not time sensitive. So things like, the reserve fund study, which is done every 5 years. Things like, the insurance certificate, which, it's updated yearly, but generally speaking.
Audited financials.
Correct, exactly.
All the stuff we normally see when we look online that we can download right away.
Right, exactly. And so, and then to your point, when you get that offer, you're only having to order 2 or 3 time sensitive documents that you're having to pay the rush fee for.
Well, and I think when you're chatting too, if you're the listing agent, you're chatting with the buyer's agent, you can educate them. I can give you all of these right now.
Yeah, you bet.
I'll order the other ones and try and get them within the 3 days. But and it's been the practice. If you order a rush, in most cases, it's 1 to 2 business days.
Yeah, I'm dealing with one right now that they're going to take the full 3, because today's day 3 and we're still waiting for it. So they're going to milk it for all it's worth. But yes, I agree. They tend to be generated fairly quickly in a lot of cases. It just depends on the management company and those types of things.
And we've always run into that. There are great management companies that are helpful, and some that you identify when you're doing a lot of them, which ones can be challenging to work with.
Yeah, you bet.
And even there, they've just, the rules have been instituted. They've got to implement them and get used to them. And
this is a really good point as well, because I was one of our office managers reached out to me at the very end of last week, just asking about an agent had contacted them saying, I'm currently dealing with a management company who doesn't have the updated fees. Right, so they're telling me it's $30 or $40, or pick a number. It's $60 for the reserve fund study, but I know that it's only $10 because it's now after January the 1st of 2000. What can I do about that? Well, again, there's no condo police. So really, I think at that point I would have to have a conversation with the buyer and say, look, this isn't right. With the seller and say, this isn't right. They should have these fees updated. But how badly do you want to sell your unit at this point? If we just have to buck up and pay this because they haven't updated it yet, kind of so be it, I guess. There's no, they, I guess, had reached out to the management company, the agent had, and really didn't get an answer. So it is what it is, right?
I agree. My advice would be, let's get the deal done.
Yeah.
Then we'll work on a complaint process with Service Alberta.
Exactly.
And report them for being in violation of the Act.
Exactly. Yeah.
Maybe you'll get some compensation, maybe you won't, but you'll have the satisfaction that with the current government and the way they're going after these things, they would probably action it.
Yeah, agreed. And so that's really kind of on the document side of things. And so the other 2 sort of pockets that we talked about were insurance and the reserve fund studies. The insurance one is interesting, and I think it's timely, just given what happened in Bankview right before Christmas with that condo fire right on 14th Street there. And I forget the name of the building off the top of my head. I'm sure people are screaming it at their screens right now. But it's interesting what the government has done with respect to insurance. One of the things that you're going to start to see is that the developer, if it's a brand new development, or if it's an existing development, then it's going to be up to the corporation. They have to come up with something called a standard insurable unit description. So an SIUD, which I probably would have picked a better acronym, but whatever. But this SIUD is going to be, again, it's the standard default insurance that the corporation will be required to carry per unit. And if you think about it, if you have a building that's 30 years old, some of the units are going to be in original condition. They're going to have the old pink carpet, and they're going to have the old pink walls, and they're going to have the Arborite countertops and all these types of things. But other units are going to be fully updated, right? They're going to have, Brazilian hardwood floors. They're going to have granite, all these types of things. So in the event of a loss, like a fire, is the corporation responsible to put back the unit to its original description, or the updated version with the cherry and the granite and all those types of things, right? And it's been a bit of a gray area in insurance up until now. But by forcing corporations, and like I said, if it's a new development, it's going to be on the developer to file this SIUD, that will give a baseline. And so anything over and above, any improvements over and above that, the individual owner will be required to insure that, right? So if you're dealing with a client who's buying a fully renovated unit, that should be a talking point for you to say, listen, this may be over and above what the standard insurable description is for this unit. So talk with your insurance provider and make sure you're covered for this. Because in a loss, they are only obligated to put it back to what that baseline is, which is not what you paid for because you paid a premium because it was fully updated, right? Or you have a client who's looking to purchase something that's in original condition currently, but they want to renovate it. Well, in addition to getting approval from the board to carry out those renovations, I would be taking a hard look at that standard description and making sure your clients are aware that they're going to need coverage to protect them, right? The other thing that's going to happen that has changed and is happening is that corporations can now require, by passing a bylaw, their unit owners to carry deductible insurance, and corporations now have the ability to charge the deductible back to the unit owner where damage originated from the unit. Now, that's already being done in a lot of cases, but previously, it tended to be malicious or negligent behavior. So if somebody was tampering with a sprinkler head in their unit and they caused a water loss in the building, I'm aware of an instance where the board charged the deductible back to the unit owner for the negligence of tampering with the sprinkler. These changes that have come into effect now, and I've seen on social media, I've seen it argued in both capacities, for and against it.
Yeah.
There was an interesting article, and if you Google it, you'll find it. It was CTV News Edmonton did the article. So if you Google CTV News Edmonton condo insurance, it was put out over the weekend. And it was a piece that was written with the input of a lawyer, a condo lawyer in Edmonton, saying that basically we've opened up a can of worms, because if you have a stacked townhouse and you have a hot water heater in your unit and your hot water heater explodes and floods the units below you, arguably you've done nothing negligent, but they now have the ability to charge the deductible up to $50,000 back to you, even though you didn't cause the issue. So what the recommendation of this lawyer is you need to make sure you have insurance on your own personal policy that would cover up to $50,000 in deductible. Because if they charge you back the deductible from the corporate policy and you don't have the insurance, you'll have to pay it out of pocket. So for me, anyone in my database who owns a condo is going to be getting an email in the next couple days advising them of these changes. And I'm going to actually copy and paste a link to that CTV article and say, listen, just so you know, these are the changes that have come into effect. Work with your insurance provider, because I'm not one, but work with your insurance provider to make sure that you have the correct amount of insurance to cover you in the event that this happens. It's, again, it's an interesting sort of take on things. The insurance world in condominiums is changing wildly right now. There's been a lot of stories of, the corporate policies ballooning by, 100 or 200 or 600% year to year. And it's because we've had so many major catastrophes in Alberta, the 2013 floods in Calgary, the forest fires in Fort McMurray, and the insurance companies are now reeling and trying to deal with this. So it's going to be a continuing thing, but that's a whole nother conversation altogether.
Full benefits charge.
Yeah.
So I love your idea of reaching out to the clients.
Yeah.
And just making sure they understand, and they need to have that conversation right away now with their insurance provider. So anybody that's got them out there, look up that link Ryan said, draft something and saying you need to have the discussion about updating your insurance to meet the current needs. Now, smart, if you've got a good insurer and a good broker you're working with, they're going to be coming to you and saying, you need to get this on as part of your update and protection.
You bet.
So, but what a great Ford call or a great service that you're going to provide to your clients by getting this information in front of them right away.
And when we were doing, so the binder's right out in front of us here, but when I do these annual home investment reviews, insurance is always a talking point for me. I'm not an insurance broker. That's not what I do. So I'm not going to go in there and try and pretend that I am. But again, this is a great talking point if you're dealing with somebody who's in, condominium ownership, just to make sure that they have the correct amount of insurance to cover them. Basically the best way to explain it to somebody is, in addition to the improvements that have been made to the unit, if you pick up your condo unit and you dump it upside down, everything that falls out of it is your responsibility. So those are, your appliances and all of your personal belongings and all of that. I think too often when agents are out showing condos, they see that the condo fee includes insurance, and they assume And therefore, the buyer assumes that means I don't have to carry an insurance policy. Well, the insurance that the condo fee includes is the global policy for the corporation, right? Yeah. And so, the net result of these insurance changes, and we're going a little bit off topic and we'll get you back here, but the net result of these insurance changes is if the global policy goes up 300% for the corporation, well, condo fees are going to have to go up because somebody's got to pay for that. And it's the unit owners who are going to have to pay for it collectively, right?
Well, and even when we look at the way condo docs are always such a strong revenue source for property management companies that are doing this, if they can't charge, and I had, when I first started selling, and you had to pick up paper copies, it wasn't unusual to see $1,000, $1,200 all the time.
Fair.
Very expensive. As things went online with condo papers, they started to get a little more reasonable, but it's a huge revenue source, and if they're being cut, they got to make up the money somewhere else. They're going to pass the cost back to the corporation.
Absolutely.
Because they're in a business, they deserve to make a profit as well.
Absolutely. And that's exactly what we are going to see and have already seen, is that the management fees on a yearly basis are going to increase.
Yep.
And so it's all well and good to say that as a condo owner, I don't have to pay $1,000 when I want to sell my unit. But if I own my unit for 7 years and my condo fees are higher now on a monthly basis because the management company is charging the corporation more money, well, I'm paying probably more in the long run than the $1,000 that it would have cost me to sell if the fees for the documents had stayed the same, right? Mm-hmm. On the paper copy note, one of the other things that they rolled out with this change to the regulation is that if you are getting paper copies, they're allowed to charge you 25 cents per page, or $10, whichever is greater. Now, I don't know many management companies that still use paper copies, but I'm sure that they are out there.
There's a couple.
Fair.
But I probably wouldn't recommend that a board use them.
Fair. Fair. Just like there's some agents that still use fax machines. I mean, it is what it is. It is what it is. Sorry. The only other changes I'll touch on very briefly, just to the reserve fund study process, they've broadened, I guess I should say, they've added clarity to who can do a reserve fund study. Okay, so they've listed off a whole bunch of people, architects, engineers, people that have a certification in doing a reserve fund study. One of the things that I think is a positive change is that they've eliminated, or they've put a restriction on somebody doing a reserve fund study who has a conflict of interest. There's a very prominent management company in Calgary where the director or owner of that management company does all the reserve fund studies for all of those corporations. There's an inherent conflict of interest there.
Yes.
And the government has now removed that ability with the changes to this regulation. The other thing that they've done is they've extended the time frame. When you do a reserve fund study prior to these changes, it was required to look 25 years into the future at depreciating common property. They've now changed that to 30 years, but they must also include stuff that has a longer life expectancy than 30 years. The benefit is, prior to this, you would have some, but not all, some reserve fund study planners would only include things that had the 25-year scope. So if you had something where the life expectancy was 30 or 40 years, they wouldn't include it in the study, which means no money is being put away in the reserve fund for that future replacements, right? So the government has come around and said, look, it's got to look minimum 30 years into the future, and you should be including everything in it. So if something has a 40-year life expectancy, it should still be in there, because now we're including all of these things, and we're accommodating for all of these things in the future when they have to get repaired or replaced. So I think, to me, that's a positive change, because it gives people a more realistic outlook on what these future expenditures are going to be. That's the bulk of the major changes that they've made.
Do you want to touch a little bit on the changes they made for builders in having to produce better pre-documents, I guess, for lack of a better word?
Sure, and these weren't changes that came into effect on January the 1st.
No,
these are changes that have been rolled out for the past 6 years.
But a lot of people don't realize they're there.
So one of the things that they've done is that if you're going to buy brand new from a builder, they now have to give you a date or range of dates for occupancy. And if they miss their range of dates, you as a buyer can go back in, cancel your purchase contract, collect your deposit, and move on. Okay? Now, how long is a range of dates? Well, how long is a piece of string? There's no specification on how long this range of dates is. But at least you're
informed of it.
But at least you're informed of it, right? And there's some repercussion if they miss their target. With respect to the deposits, the way that obviously our legal system works is that politicians create law, lawyers figure out ways to circumnavigate or amend the law, right? So the politicians created this law.
You mean they work on their best interest of their client?
Correct. Yes.
Yeah, that's what I thought you meant.
Right. So they, the politicians created a law which says all deposits now for a new condo have to be held in trust by a lawyer. Okay? The lawyers for the builders, working in the best interest of their client, said, don't worry about it. Alberta New Home Warranty will protect up to, and I think it's $25,000, but I have to go back and look at that. But Alberta New Home Warranty will protect up to $25,000 of a deposit. So the way that most builders' contracts are now structured is that the deposit is not held in trust by a lawyer, as it should be. It's held by the builder, and the builder turns around and points to Alberta New Home Warranty and says, don't worry about it, Dave. Your deposit's protected because we have Alberta New Home Warranty standing behind us. For those that have or have not dealt with Alberta New Home Warranty, it's an insurance program. And like most insurance programs, they will look for reasons to not have to deal with something if they feel that there's a loophole or somebody else is potentially at fault or these types of things. So to me, the politicians had it right. The deposits should be held in trust by a lawyer. But in practicality and what's happening right now, most of the time that's not the case. The builders are still holding the deposits because they're pointing to Alberta New Home Warranty and saying, don't worry, there's protection there. With respect to the list of documents, it is more robust. And for those of you that don't know, a new condominium purchase is the only purchase that exists where you have a right of rescission. That right of rescission is 10 days. So by the time you receive all of the documents from the builder, so these are going to be things like the proposed budget, these are going to be things like all of the drawings for the entire development, the phased disclosure statement, all of these types of things. When you receive all of this, you have up to 10 days to walk back into the builder's office and say, I changed my mind, I want to cancel my contract. You don't have to give them a reason. Mm-hmm. You can just cancel it. They're required to give you any deposit back and you can, go on with your life. So that's just something to be aware of if you're working with somebody who is buying brand new in the condo world. With respect to the budgets, again, these are changes that took effect about a year ago, but they're trying to hold builders accountable for their budgets.
So they set realistic condo fees.
Correct.
So we don't have to tell our client, it's at 150, but when they turn it over to the corporation within 2 years, it's going to go to 300 or 400 like everybody else.
Correct. And so the builders are allowed to be 15% wrong. So for example, if the proposed annual budget was $100,000 a year and it ends up being $115,000 a year, that's okay. But anything over and above that, the corporation can charge that back to the developer. The other thing that they've done, sorry, I had a point to make there, but I completely lost my train of thought. I'll think about it in just a sec.
I like it in that we're hopefully going to get, or are getting, more realistic estimates of what condo fees are going to be on new developments now.
Well, that's
hopefully.
The hope. That is the hope. And sorry, the point, I did remember the point I wanted to make. The corporations also have the ability to cancel the contracts that the developer has entered into, because what happened a lot previously is when the developer was in control of the development, they need somebody to shovel the snow and cut the grass, but they don't want to have to pay a lot for it. Mm-hmm. So they would enter into a 5-year contract with a snow removal or landscaping company, but it was back weighted, right? So for the first 2 or 3 or 4 years, the snow removal company doesn't make a lot of money, but they make all their money in the 4th and 5th year when the developer's no longer involved, which means they're not paying for it, but the burden is then passed to the new unit owners and the new board to deal with this contract. Well, now boards have the ability to cancel the contracts that developers have entered into, which prohibits them, hopefully, from entering into these back-weighted contracts to the benefit of the developer, right? So.
Great information, but we're definitely a little over on time.
Sorry, I talked a lot.
Going, and he's going to get blamed when we run past 10:30. So
fair.
That's all right. It was great information. There was a lot we covered today. When it gets archived up, take another look at this. You can certainly reach out and we'll help you with any questions you have on the new condo changes.
The other thing I'll mention very quickly as well is Area is going to be putting out a podcast either late this week or early next week with a lot of this information as well. So if it was too much in a small period of time today, check out Area's podcast later on.
Perfect.
Thanks, Dave.
Thanks, Ryan.
Thank you.